on the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha and welcome to Business Law 200. This course is offered through Kapiolani Community College, the Department of Business Legal Technology, also referred to as the BLT department. So if you're getting hungry, take a stab at that. We also refer to this as BLAW200, and it is the legal environment of business. So we'll be looking at the environment in which business operates, which common sense will tell you is also, for the most part, the environment in which we all operate. So we'll be looking at law in general. My name is Ben Carroll. I've been an attorney for 35 years. I've done quite a bit of trial work. I've advised businesses. I've been in both federal and state court, done a number of appeals, represented unions, management, etc. So every now and then I'll probably tell you what we call a war story. In other words, an example that I hope will nail things down for you and make the law a little bit clearer. Let's start out at thinking about what the law is. In other words, what is law? What do you picture? So you might picture an edifice. You might picture a fancy courthouse built of marble. You might think of one of the other buildings where the law is made. For example, our state capitol or one of the typical domed capitals like we have in Washington. You might think of other places that are involved in the law. So you might think about perhaps jail. You might think about the effects of breaking the law. So you might think of prison or something of that type. So whether you think of where the law is made or where it's enforced, that sort of thing, that's one possibility when we start thinking about the law if we try and picture it. Another thing you might be thinking of are the people involved in the law. So it might be the prisoners, might be the judges, other people involved in making or enforcing or interpreting the law. So you also see the gavel here, and we'll talk a little bit about what that means as well. One of the things I like to think about, and typically a lot of people have obviously had this same approach, is statute of justice or the statute of the law. And of course, we'll talk a little bit about whether law and justice are the same thing or whether one leads to another, etc. But this is a fairly common kind of statutes that you'll see here. And there are a number of features that are quite common. Many of the statutes will have a sword. Many of the statutes will have a balance or scales. And quite often you will find that the justice or lady law is blindfolded. So, well, what do all of those symbols mean? Why do we typically think of that as being law and justice? Well, first, I'd like to kind of think about lady law with the blindfold on. Does that seem a little strange to you that we want justice to be blind, that we want the law to be blind? Okay. Well, first of all, she's not blind, she's blindfolded, and there's a difference there. But why would we want a blindfold on someone that is representing what we expect the law to do, what we hope the law to do? Well, this means that the law is going to be administered objectively. So this is going to be without favor, without prejudice. It's going to be irrelevant what your status is. So justice is intentionally not looking at who's in front of her. So by that we think of fairness and equity, and that's why we have the blindfold on in many of the representations that we have. Okay, well, what about the sword? What's that all about? Well, I think of the sword as being kind of similar to the gavel. So what we're looking at when we think of the gavel is, and the sword, is we're thinking about the power to enforce. In other words, the authority of the law. So if you break the law, there will be penalties. There will be sanctions. The government, the law will take you to account for that. So that's what we mean with the sword. And I think of all the representations, probably the balance or the scales is the most common and the most understandable. So what do we mean when we look at the scales? Well, we're balancing people's interests. We expect things to be fair, for things to be equal, things to be equitable. And so that's what the scales mean. So hopefully the scales are even. I think some of the representation scale may be a little unbalanced, but we'll work on that. Okay, so you will be seeing Lady Justice or Lady Law will start appearing down in the corners of our slides because we want to keep her in mind. I did eliminate the sword, but you know that the power's there. We will be talking about that. But the important things really are that it's going to be objectively administered, it's going to be fair, it's going to keep everything in balance. And we'll be talking a little more about that as well. Okay, so what are we going to do this first session? Well, we want to get an idea of what the course is about. So we will talk about overview of the course, how it's set up. We'll talk about the things you need to participate in the course, the requirements. Obviously, since we're on cable TV, which you are aware of if you're watching, you'll need to have that capability. You'll probably also want the capability to tape a session so that you can either go back and review, or if you are not able to see it at the regular time, you'll be able to view it later. Hopefully there will be some possibilities of having it posted as well. In other words, we may be able to post the videos on the website or elsewhere, but those typically are going to be smaller and not as viewable, so you may want to make your own taping arrangements as well. We'll be talking about where to find the materials. Those are going to be online. Most of our work will, in fact, be online, so you'll need computer capability, reasonably fast internet, and those requirements are all posted as well. Okay, so what are the course components? Well, obviously, this is one. We'll be meeting this way and going over the course material via the cable video. We'll also have a lot of posted materials, so there will be a lot of written materials that you'll need to read and take into account. And again, those will all be posted on the internet. The law pretty much operates in print, so be an awful lot of reading. So be aware of that, and we will talk about how to make that easier and how to make that understandable for you as well. We are going to have online discussion. Since we aren't meeting in person, our discussions will be online. So mostly those will be what we call asynchronous, which means that we will post questions and have a discussion, and we won't need to be online at the same time. So people will write in their thoughts, and then other people can respond and put their thoughts in as well. And for the most part, you can be doing that at a time that's convenient to you. There may be opportunities to meet together online at the same time, and you'll receive ample notice if that happens. Okay. There'll be a number of exercises that will be submitted online, so we'll be looking at things to help us understand the law. We'll actually learn to read cases and understand what has been passed by the legislature, all that sort of thing. And we'll have short exercises and assignments that will help us to get familiar with that so that we can understand what's going on. And then finally, there will be some quizzes that will be online. Those will be totally online as well. So as long as you've got your TV and your internet, you're probably good to go here. Okay, I want to talk a little bit about what we cover. So as I indicated earlier, we start out with just the basic legal system. Before we talk about business law, we have to understand a little bit about law itself. And I should let you know, business law is not a formal category of any type. It's not a specific subject matter area for the most part. It's simply a term we use to refer to the types of law and the parts of the law that are most applicable to business. So the average law school is not going to have a course called business law. Okay, you're going to be doing different subject matters, things that we will cover in this class, but are not all grouped together, such as corporations, agency, contracts, that sort of thing. Okay. We will also be talking about the substantive law, so we will talk about the law that applies to various subject matter areas. We'll talk quite a bit about the procedure, so we'll need to know how laws are passed. We'll need to know how they're interpreted, and we'll need to know how they're enforced. Okay, and then we'll get into the areas that are specifically business related. So we'll talk about the various business entities that can be formed. So you'll learn about sole proprietorships, mom and pop businesses, which we have a lot of in Hawaii. We'll talk a little bit about partnerships. We'll talk about corporations, kind of the big guys. And we'll talk about a number of new types of entities, relatively new types of entities, that limit liability. So we'll be looking at all of those areas. And so these are kind of some of the major categories of what we'll be considering. And let's break it down a little bit. This is a survey class, which means we'll be covering quite a bit of material. And let's just take a preview of what that's going to look like. Okay. Well, we'll talk about the legal system. And our legal system in the United States is quite different from the rest of the world, most of the rest of the world. And we call it the common law system. And you'll do some readings. There are various discussions of what common law means. Is it common to the entire country? Is it for the common man rather than the nobility, rather than the elite? Number of different interpretations of where we got the term common law. But the long and the short of it is, this is law that originated in England. So our legal system owes an awful lot to what developed in England many centuries ago. You will find common law around the world only in those places that had an association with England. So what are we talking about? We're talking about the United States. We're talking about Canada. We're talking about Australia, New Zealand. We're talking about, to some extent, India, other areas that had British influence. And that's basically where the common law exists nowadays. Now, what other systems are? If their law in most places is not common law, what is it? Okay. Well, in one sense, civil code jurisdictions are the majority of the countries around the world. And these actually came from Napoleon, so also sometimes referred to Napoleonic Code or Napoleonic law, from the French general and statesman and emperor, and sometimes also may be referred to as Roman law, because there's some background there. And what's the difference? Well, again, we'll get into this in a little deeper, but generally, civil law relies on what's passed by the legislatures, by the government, whereas common law adds another level and is based on what the courts think of it, so the interpretation. So in a common law jurisdiction, the courts are very important. We'll talk about this more, but a court interpretation is quite different in common law area. They can't do that in civil jurisdictions. Any other kinds of law? Yes, for many years there's what we call socialist type of law, very administrative, very top-down, didn't much care about electoral or legislative enactments. It was quite top-down driven. Most of those jurisdictions since the fall of the Soviet Union are adopting civil law or common law or combinations thereof. And then finally, there are a number of countries that have religious law. In other words, their law is exactly the same. Their religious code is, in fact, their civil code as well, their government law. There's no difference between what the commandments come out of the religious writings or the holy books and what is enforced. Okay, so obviously that's quite different from the United States, where we have separation of church and state. So again, just a quick look at that. We will be talking about those differences and what the basis is. Another important thing in our system is federalism, and this differs in the United States from the other common law jurisdictions for the most part. Federalism, again, happened historically, and it means we're a federation. In other words, we are a group of states, so each state makes its own law, and we also have federal law or U.S. law that applies in the states as well. So we have two different systems going in every state, which means we have 50 states and District of Columbia making laws of various types, and we have Congress making laws for all. So we'll talk about that. Has to do with what we call jurisdiction, in other words, which court is in charge, which law applies. So we'll be looking at that. Another just general part of understanding the law is to understand law, ethics, and morality. So these are distinct, and sometimes they're together, sometimes they're not. So sometimes the law will also enforce what we consider to be an ethical concern, and it will correspond with what we think is a moral choice, and sometimes it won't. So you can probably think of instances where the law and your own sense of morality, or someone's sense of morality, differ considerably. So what kind of cases might those be? Well, generally these are very intense, value-laden areas such as life, in other words, abortion, contraception, end of life, assisted suicide, these types of areas where some people feel that the law is different from and not consistent with their sense of morality. So we can have a law that we think is immoral. We can have law that we think is unethical. Many times the law will, in fact, incorporate our sense of ethics and morality, but not necessarily. And we'll talk about the differences, and we'll talk about specifically business ethics, business morality, so to speak, as well. Okay, so in addition to just generally kind of getting that background and getting a feel for the legal environment, we'll be looking at the sources of law. So in the United States, the Constitution is the supreme law of the land. So everything stems from the Constitution. Okay, this may take you back to a civics class way back when, and you'll recall 3 branches of government. They're set up in the Constitution. You may recall terms like separation of power. In other words, again, some historical background that the states were and people were not were hesitant to have a strong central government, and they were hesitant to have too much power in the executive. They had trouble with the king, you may recall. So we have a separation of power and we have a balance of power. Okay, so we'll look a little bit at that. That affects how our law is made. Again, Constitution is supreme, so everything goes back to the Constitution. The legislature will pass laws, and we talk about passing law, but really what we're talking about is passing a statute. So they pass statutes. We will look at the interpretation of the law, and that's done by the courts. And this is an area, again, as we talked about a little bit, where common law is quite different from other places. In civil code jurisdictions, the courts are not able to do much interpretation of the law. Interpretation of the law is done by other experts, government experts, not by judges. Okay? In our system, the judges can interpret the law. The ability to interpret the law, in the opinion of many, is also the ability to make law. And one feature that surprises a lot of people from other jurisdictions is the fact that our court can declare a law unconstitutional. In other words, a court can decide that this law is not consistent with our U.S. Constitution. And the Constitution being the supreme law, what does that mean? It means that the law passed by the legislature, passed by the people's representatives, will not be enforced. It will essentially be voided, thrown out, because it is not consistent with the Constitution. Well, how in the world did the court get that power? We'll talk a little bit about that as well. And there are people who still are unhappy with that. They say the court is making law and shouldn't be, and, well, that argument's a couple hundred years old, so good luck with that. And then we'll talk about the executive. So the executive we think of as enforcing the law, in other words, the various agencies and departments that will actually literally enforce the law, but also the executive can produce law, because the executive includes not only the person, the chief executive, but also various executive departments and agencies. And these departments and agencies make an awful lot of law. They make various rules and regulations. And we'll look at some of those. There are hundreds of these federally and scores of them in the state that make different rules and regulations that will affect our business and our lives. Okay, so as we looked at, the legislature makes the law, judiciary interprets the law, and the executive enforces the law. Now, in a sense, I think you can say they're all making the law, but if you're more comfortable, then we will say make the law, interpret the law, and enforce the law. Okay. Okay, we'll also spend some time with how to understand the law. It's a new language, so we'll try to avoid the Latin, but every now and then there's going to be some Latin that comes in. So it's going to be good for you to get probably a law dictionary, or at least to look at the glossary in the materials so that you can look at words you don't understand. Many times we'll also find that the law uses words in a different way than our common understanding. And to make matters worse, again, for historical reasons, we will often use 2 or 3 words that mean the exact same thing. So we'll talk about give, devise, and bequeath when we're talking about making a will to pass our property to our heirs. Give, devise, and bequeath. Well, some lawyers may try and make distinctions between those, but really they all mean the same thing. So why are we adding those extra words? Maybe we get paid by the word. No, actually that's not it. We do that because we have Latin roots to the law, particularly as we mentioned, the civil law had that, and we have some of that in common law. We also have French from the Norman Conquest, and we have Anglo-Saxon English. So many times, to cover all our bases, we're going to use all those 3 different languages in the law. Now, there is a plain language movement. We're trying to make things much more understandable, but to the extent that we need to kind of learn a second language, legal language, we will be doing that. We'll also be looking at how to read the law and apply it to our situation, because that's obviously what we're interested in. As an individual, as a business, we want to know how a law is going to affect what we're up to. So keep ourselves out of trouble, make good decisions, etc. So we'll need to understand how to read the law and how to understand it. And just a quick note, one of the concerns with applying the law is that the statutes are written broadly. They're meant to apply to everyone, but we're not concerned with how they apply to other people as much as we're concerned how they apply to us. So the legislature will pass a broad statute, but the courts will have to apply that to a very specific situation, because when a situation comes before the court, it involves particular people in a specific situation. So we're applying a broad law and seeing how it applies to a specific fact situation. And we'll learn how to look at other cases to see how that works and to see if we can predict how it's going to be applying to us. Okay. So again, we'll also look at how to read a case. The cases get published in big volumes. They've been publishing cases for hundreds of years, and we will learn some of the tricks of how to read a case written by a lawyer or a judge, justice, and how to translate that into plain English and understand how that affects us. Okay, we're going to be talking about the courts. As we indicated, in the common law system, the courts are extremely important. We've got several sets of courts. We obviously have federal courts and state courts, and then we have different levels of courts. So we'll be looking at the different levels of courts and what they handle. Again, mentioned this word earlier. We're talking about jurisdiction, so which court has the power to handle particular matters. And you're probably aware that some matters are only handled in federal court. One example is bankruptcy. So bankruptcy is handled by a federal court. Many other matters are handled in state court. We have trial courts where we originally go when we have a problem, and then we have appellate courts. Appellate courts hear the appeals, so if you lose at the lower level, then you will appeal your cases. So we'll be looking at a lot of these procedural how-to kinds of things, how cases arise, how they're handled, etc. Okay? We'll be looking at these procedures. We'll also look at substantive areas, and we'll be looking at those in a minute. Substantive areas are the subject matter of the law. So if we want to know what constitutes a contract, how do we have an enforceable agreement, then we'll be looking at substantive law. If we want to know how to bring a lawsuit about that particular problem, that's the procedural law. So we'll be looking at both of those areas. And finally, we'll be looking at what's known as ADR. And nowadays, many people know that ADR stands for Alternative Dispute Resolution. And the alternative is an alternative to litigation. In other words, an alternative to going to court, filing a lawsuit. So when we talk about alternative dispute resolution, we're talking about all the different things you can do to resolve your disputes short of or other than going to court. And Hawaii courts are particularly in the forefront in this area, have been recognized nationally for incorporating a lot of dispute resolution other than lawsuits into the court process itself. So many times they will refer cases out and have them either mediated, arbitrated, negotiated, otherwise handled outside of court. And we'll talk about what the benefits are. I'll just give you a quick preview. Is most cases never go to court. And of the cases that do go to court, the vast majority of them never go all the way to a judgment, all the way to the end. They get settled in various ways before that time. So the alternative dispute resolution is quite important, and we'll be looking at that as well. It's also, in most instances, going to be a lot less expensive, a lot less wear and tear, a lot faster to handle it that way. So we'll certainly look at that as well. Okay, so let's talk a little bit about some of the subject matter areas that we will be covering. As I said, this is a survey class, so we're going to zip through these, and of course, the rest of the term, we're going to be getting into the nitty-gritty of them, but let's just do an overview and give you a flavor of what we're going to be looking at. So we're going to be looking at torts. If you speak Spanish, you may think tort is a sandwich, but in this case, a tort is a civil wrong. So a tort is where someone has injured another person or their property. This is distinguished. The reason we say a civil wrong is because if somebody injures a person or property, we may also be dealing with the criminal law system. Okay, so the tort is the civil side of that. So perhaps to make this a little clearer, many of you are familiar, at least from having read or heard about the O.J. Simpson case. So there was a criminal charge brought against O.J. Simpson, a former famous football player, that he had killed his ex-wife and a waiter, so Nicole Brown and Ron Goldman. And so the state of California brought a lawsuit against a criminal proceeding against Simpson for murder. Okay, and that trial ended with a not guilty verdict. Okay, now the murder, the killing, was not only a crime for which the state went after Mr. Simpson, but it was also a civil wrong. In other words, the families of the people that were killed, Brown and Goldman, also had a claim against Simpson because he had taken away their loved one. So that killing is also a tort, and we call that wrongful death. But there was a separate action brought by those families against Simpson. And in that case, Simpson was found liable. It was found he had killed them. So we'll talk about the differences in civil and criminal. But in that case, he was found that it wasn't proven he had killed them in the criminal case, but it was proven that he had killed them in the civil case. And you may wonder, how did that come about? Again, that's one of the things we'll talk about. Okay, so we have a civil wrong, and we divide that into a number of categories. First is intentional, so this means that you intend to do an action. You may not intend the result, but you intend to do the action. And we'll talk about a number of these. And these are familiar, and you also will have heard of these as crimes. As I indicated many times, these are crimes as well. So if we talk about assault and battery, you know that that's making somebody afraid and or hitting them. If somebody slanders someone else, that means they've said something that's damaged their reputation. And there's a number of these intentional torts that we'll talk about. We'll distinguish those. Now, we can also do a wrong to someone, but we didn't mean to do it. In other words, it's unintentional. So most of you are familiar with the term negligence. So if we're negligent, it means we haven't acted the way we should have, or we have acted the way we should not have. Okay, so we have been negligent. We haven't acted as a reasonable person would, and as a result, we've damaged someone. And then finally, there's strict liability. And strict liability is also known as absolute liability, and sometimes it's referred to as liability without fault. So what this means is it's liability without negligence. You haven't necessarily done something wrong. You have injured someone. And we'll talk about why we have this. Why would we hold somebody responsible if they did the best they could, the best that anybody could do? And again, give you a quick preview. We do that if they're doing something that we consider to be unreasonably or abnormally dangerous. Okay, so they're using explosives, radioactive material, etc. And this will come up oftentimes in products cases as well, where a product is considered to be unreasonably dangerous. Okay, so that's one major area. We'll also look at contracts, and this is what we typically think of as being a business area. So what's a contract? Well, in essence, it's an agreement, and we'll talk about how to make enforceable agreements. So we'll talk about how to form them, how we have to agree, how we have to understand what we're doing, how we have to have a fair exchange of value for it, and how it has to be for legal subjects. So we'll talk about the elements of making a contract. We'll talk about what happens when you breach or when you fail to do what you're supposed to do under a contract. We'll talk about the rights of third parties. In other words, what if what your contract is about affects someone that's not a party to the contract, that didn't sign the contract? So we'll look at various ways that these voluntary agreements operate. So you can see we've got torts, which for the most part are kind of unintentional or unintended dealings with other people. And we talk about contracts, which is where we are actually voluntarily interacting with other people. So those are, again, two major areas we'll look at. Okay. We will then get into areas that are considered even more of the business law area. And this starts with the Uniform Commercial Code. So code is really another word for statute. So Uniform Commercial Code is a statute that tries to make all of our commercial dealings uniform. In other words, the same. And if you think about it, it makes sense. If we use a credit card in one state, we want to be sure it's going to be properly handled in another state. So obviously our commerce, our business would be a mess if we had different rules and regulations concerning checks, bills of sale, and various other documents that went between the different states and different countries. So the Uniform Commercial Code is been passed in every state, and we'll talk about uniform laws, but specifically we'll spend quite a bit of time with the Uniform Commercial Code. One of the major areas that you deal with every day is called sales. So sales means that we're exchanging goods, and we'll talk about special rules for people who sell goods regularly all the time, and we call them merchants, and they have some specific responsibilities since they're considered to be somewhat of experts in that area. So we may have a higher standard for them. We may have certain requirements for people that would fall in that category. We'll talk about negotiable instruments. Sometimes this used to be referred to as commercial paper, but negotiable instruments are simply documents that act like money. So you're all familiar with this. Maybe you use a bank card now, but you use checks, which are kind of one of the most common forms of commercial paper or negotiable instruments. So we'll talk about how that works. This obviously would be, I think, of interest to you not only in business but also in your personal life, bouncing checks, etc., credit, that sort of thing. And we'll then look at secured transactions. So kind of the analogy here is mortgage, or if you buy a car and you not only have an ownership, but so does someone else. So we'll talk about what secured transactions are as well. Okay, other laws and areas that we'll be dealing with in transactions is we're going to talk about liens. Okay, so a lien is a property interest held by someone else. And again, if you buy a car, many folks are going to buy a car and you're only the partial owner, right? Who else owns it? Either the bank or the car company. So they have a lien, and that means they have an interest in that car. So you're not able to go and sell it and keep the money because you're not the total owner. So we'll talk about how liens work. We'll talk about bankruptcy. Unfortunately, that's in the news more and more. We'll talk about how bankruptcy works, and we'll talk about intellectual property. So intellectual property is product of your intellect. So what would that be? Well, typically we would think of copyright. In other words, you have produced something either in writing or a play or a video or something that is unique, original, and you want to protect it. So you don't want to have other people making money off something that you have created yourself. Intellectual property also includes patents. When we think of patents, what do we think of? Well, most people think of some kind of invention. Again, we're protecting an original thought, an original way of doing something, and so we will patent something. And you're quite familiar with particularly pharmaceuticals, drugs that have been patented. And we'll talk about what happens when the patent expires. And again, you're familiar with this. We have generic drugs, so people can now produce the same drug because the patent has expired, and now anybody can make it. Okay. Now, if you make it, can you call it the same name that the other person gave it? Nope. They have an interest in that name, and that's the trademark. So they have an interest in value that they have built up with a name or a logo or a slogan or something else. So we'll look at that as well. And this whole area is intellectual property. That kind of leads us into the internet, because internet is a great way for stealing people's intellectual property, because anything and everything is posted. And we'll talk a little bit about some concerns you might have about using things you find on the internet, because simply because it's available does not mean you have a right to use it. Doesn't mean that people have given up their rights to what's on the internet. So we'll talk about safe, legal use of the internet, some things to be aware of, that sort of thing. And we'll talk about e-commerce, in other words, doing business over the internet, which has obviously exploded, continues to move rapid pace. And again, we'll talk about some things to be concerned about if you're a eBay auction fan or do other kinds of transactions over the internet. Okay, we'll be talking about business relationships again, and this is an area that we typically think of as business law because we're talking about how businesses operate with each other. So we'll talk about what an agent is. Okay, you think of agents typically as being perhaps for a sports figure, someone rich and famous has an agent to help them in their career. We have agents all the time, so probably everybody will employ a real estate agent to help them. And so we'll talk about what that relationship is, what the responsibilities are on both sides between an agent and the person who hires them, known as a principal. Okay. We'll also talk about the basic employment relationship, because most of you are already employed. If not, you'll be employed soon. So we'll talk about the relationship of employee and employer. We'll talk about a related relationship of independent contractor. We'll talk about the differences between the two. We'll talk about your rights and the rights of the employer. We'll look at employment discrimination. Okay, obviously, this is part of larger discrimination laws, but we'll talk specifically about employment discrimination and the protections that are provided to you in your work. Okay, this is pretty wide-ranging, so many of you have heard of different civil rights or employment laws that may affect. You've heard about the different benefits that you're entitled to as an employee, rights you have, and we'll certainly look at this and give you a good background in that. And we'll look at labor law in general. So we'll look at the relationships between labor, which we think of are groups of employees, usually with a union, and management, which are the employers or the management groups. And we'll look at those relationships. Just a little bit of history to see how that works. Many of you are probably aware that Hawaii is one of the states that has the most heaviest amount of union members, I think, after New York State. So we have quite a bit of union activity here, again, because of the history we have. And we'll look a little bit into that as well. Okay, the business entities themselves, in other words, if we're going to do business, we will select a way of doing business, a method of doing business, and that's all going to be governed by our state law. So sole proprietorship, again, these are the mom and pop businesses. Hawaii has an awful large percentage of small sole proprietorships. We'll talk about the pluses and minuses, the pros and cons of using these various types of business or forms of business. Sole proprietorship, if you think about it, you can probably guess what the main benefit is. You get to make the decisions, you get the money. But the flip side of that is you also get the losses, and you may be responsible with your personal assets. In other words, they can come after your house perhaps, or your car, or some other assets that you have if your business fails. We'll talk about partnerships where you join with other people. Third major categories, we'll talk about corporations. Okay, and corporations are substantially different because we are now separating the owners from the managers, and this has some important protections from us. It allows us to protect our own personal assets if we're involved in a corporation. So that's a major difference from the partnerships and the sole proprietorships, and the reason that many people would look into a corporate entity as the way of doing business. And over the last few years, we've had a number of other organizations that try and combine the benefits of, for example, a partnership while avoiding the downside of a partnership, which would be the unlimited liability. So you'll see a number of these, and most of them will have LL, limited liability, in front of them. So we have limited liability partnerships, limited liability companies, and these are intended to give us the best benefits of control and yet avoiding the personal liability. So we'll look at those various possibilities. Again, these are governed by state law. All sorts of other possible business associations that we'll touch on as well. So there are unincorporated associations, there's ecclesiastical or religious corporations, there are professional corporations, and we'll look at those various possibilities as well. Okay, and we will also look at how business is regulated. So this entire area is known as administrative law, and this typically comes from the departments and agencies we referred to that are part of the executive. So there will be regulations about how these departments and agencies that govern particular types of businesses operate. So, for example, we have the DCCA, the Department of Commerce and Consumer Affairs, and it regulates various industries. For example, if you're a masseuse, you're regulated. If you're a mediator, you're not. But we'll look at how these regulations govern activities. Particularly when we're dealing with corporations and big business, there are many, many other regulations because of the power that can be garnered by large organizations and companies. And when you think about it, there are some companies that are so big and have so much of the market that we're concerned that they may be able to dictate prices and monopolize particular areas of business. So we'll look at some of those occurrences. Some of you may recall that Microsoft, software maker, was charged with being a monopoly and trying to run other companies that were competitors out of business. So We call that antitrust. Okay, trust being an old word for monopolies for big businesses. And we'll look at antitrust and some of that protections we have in that area. And then finally, an area that will be of interest to you, particularly as a consumer, as a individual, as well as a business, we'll look at a lot of these commercial protections, consumer protections that you have as an individual. So we'll be looking at protections for health and safety. We'll be looking at regulations for advertising, where people are trying to convince you to buy something, and there are regulations about how they can do that. So to avoid fraud, misrepresentation, that sort of thing. We'll talk about various regulations about credit. In other words, there are protections for you from the credit companies, and we'll look at how that works, how they can collect if you haven't paid, whether or not they can harass you, that sort of thing. And we'll look briefly at some other areas of interest to you, such as landlord, tenant, etc., and the protections that you might have in those areas. We will also be touching on international law. We'll be talking about that in various areas as well, because more and more business, as we indicated with the internet, does involve dealing with other countries. So we'll touch on the differences with doing international business as well. And of course, we've already pointed out briefly some of those possibilities. In other words, many countries do not have the common law tradition, so they certainly don't have the same relationship with their courts. And we'll talk about the reach of American law outside of the country as well. In other words, do American companies only have to, when they're operating in a foreign country, do they have to follow American law as well as the law of that country? That sort of thing. Okay, we're going to have some general themes that we're going to go over during this course, and so I'm going to talk about a couple of them now, but themes kind of help us put together the many, many areas. As I indicated, this is a survey class, so we'll be looking at, as you've seen, a whole lot of law. And we kind of want to look at some themes to see if we can tie it together and come up with some ideas that help us keep everything making sense to us. So we have stability and flexibility, the idea of reasonable people, and the idea of balancing interests. So what exactly do these mean? Okay, stability and flexibility, we're talking about the law being predictable. So it allows us to plan things. We know what we think are going to happen. And yet, we also need to adopt when conditions change, or if the law in this particular application simply just doesn't seem fair to our sense of morality, ethics, the law, whatever. So stability and flexibility. What would be an example of that? Well, most of you have probably heard of a decision 50 plus years ago called Brown versus the Board of Education. Okay, and this was a case that was brought at the time when they still had separate schools for white children and African American and black children. And the law previously had said it's okay to have separate schools as long as they're equal, as long as both races are receiving the same benefits. And so the courts had followed that and had said, our concern is to make sure that everything's equal. It's okay to separate people as long as they are getting equal rights, and that was the law. This particular decision looked at it and decided it really isn't fair, because if you are not in the mainstream, if you're not in the mainstream schools, you're not getting the same education. Okay, so even assuming that you were providing equal, it's not really fair, it's not equal, because you're keeping people separated from the majority population, etc. And in that particular instance, they actually allowed evidence that wasn't strictly legal evidence. In other words, they allowed in some sociological studies and some other materials, kind of the first time they'd done some of that. And the court decided to change. So it had the flexibility to change and actually overrule prior decisions. Okay? So we do want that flexibility, because if we continue to follow the law just because that's the way it's always been, if we have a bad instance or a bad law and we keep following it, not a good result. So we do need the ability, the flexibility to change if something's brought to our attention or if things change, that sort of thing. Now, is the stability and predictability good in general? You bet. We want to know, if I do this, I know what's going to happen. I can plan. I know that in past situations, when this particular business organization has been set up, it had these rights and responsibilities. I know that if I handle this particular way, then I'm good, because that's the law has already been interpreted, and that's okay. So we'll be looking at that balance between stability and flexibility. Okay, the reasonable person. Okay, we'll be talking about the reasonable person. So the law expects us to act as a reasonable person would in similar circumstances. So we are all reasonable. We treat each other reasonably. That's what the law expects. Of course, the question is, who's a reasonable person? And again, we'll look at this more as we get into the subject areas. But a reasonable person is not your average person. It's not a normal person. This is a person we have created hypothetically that's kind of the best person. So this is a person who's always attentive, always fair, always paying attention, is courteous, kind of like the Boy Scout oath, kind, etc., etc., etc. So we'll be looking at the reasonable person, and we'll use that as our standard. Okay. And the last one I'd kind of like to look at, and this takes us back to the balance, the balancing of interests. So the law attempts to balance the various interests that come in front of us. And so we may be balancing one person with another. We may be balancing society as a whole with another person. We may be balancing between different groups. So there is a balancing here, a fairness, and we're trying to do equity. So we're trying to get the proper balance. And so what might we balance? Well, we might be balancing somebody's right to privacy with the public or someone else's right to know. So again, there's kind of a constant balancing that we will be doing here. So these are just a couple of the themes that will come up. We'll be talking about, again, themes to try and tie things together as we go through the course so that things make sense and you can see how one thing relates to another and how the law builds on what went before and other areas. So we'll try and make it make sense to you. As I said, there will be new terms, so on occasion we will have to learn a little bit of new lingo. And to do that, we're going to have, every now and then, the little lawyer will come in and explain a term to us. So if we're using any Latin or if we're using something that doesn't seem to be the normal way we would use things, then we're going to have a little lawyer come in and will give us some help with that. And you saw that he's wearing a suit, so I won't have to. I'm going to be comfortable just like you are most of the time. Okay, so I hope that gave you an overview of what we're going to be up to. Take a look at the website, and you'll see where the materials are. There'll be the syllabus, there'll be schedule, all that sort of thing. And we will get into the nitty-gritty and start looking at the law in more detail in our next session. So, this is Ben Carroll saying aloha from BLAW200. I'll see you next time.